Go on record in state of Wisconsin versus Katrina Bauer, 24 CF 163. Appearances starting in the courtroom.
State appears by Jacqueline Labrie.
And on Zoom.
Katrina Bauer appears with their attorney, Ann Larson, by Zoom from the Manitowoc County Jail.
The matters on the calendar for a preliminary hearing today. I had an opportunity to talk with counsel earlier. Attorney Larson had filed previously a motion to modify bail, and then I think it was late yesterday, filed a motion to dismiss count one. My understanding after talking with counsel is that Attorney Labrie anticipates filing an amended complaint, and based on that, the parties are asking to adjourn the preliminary hearing 1 week and proceed with the bail motion today. Attorney Labrie, is that your understanding as to how we're proceeding?
Yes, Judge, and I did file the amended complaint prior to coming to court today. I emailed a copy to Attorney Larson and the court.
And Attorney Larson, that's your understanding as to how we're proceeding today?
It is, Your Honor.
So what the court is going to do then is this: as it relates to the preliminary hearing, in light of the filings, I'm going to find good cause to toll any applicable time limits. I'll adjourn the preliminary hearing to March 14th at 10:30.
Judge, were we
Yeah.
going to do that at 11?
Oh yeah, sorry. We'll do it. We'll adjourn to March 14th at 11 o'clock. Thank you, Attorney Larson. That leaves us with the bail motion then. Attorney Labrie, did you have an opportunity to review the bail motion?
Judge, I did have an opportunity to review the bail motion.
All right, Attorney Larson, go ahead.
Your Honor, we are asking that the court reduce the bond to one of a signature. I would note that Ms. Bauer is a resident of Wisconsin. She's a lifelong resident of Wisconsin. She has no serious record. She has 2 prior CMs of disorderly conduct and 2 CTs. She had no misses in the 2 CMs, which were in 2011 and 2015. In 2017, she had the 2 CTs I referenced. All of these were in Outagamie County, with the exception of the first, which was in Winnebago County. In the 2017 cases, she did miss court. She missed court on June 17 to CT 236. She missed court on June 23rd of 2017. A bench warrant was issued, on June 21st, but on June 23rd, the bench warrant was not issued. In 17 CT 752, there were several warrants issued. There was one issued on February 5th of 2018. She was appointed an attorney on February 7th, and the warrant was canceled on February 9th. On May 16 of 2018, a bench warrant was issued. On May 23rd, bond was reinstated. On August 14, a bench warrant was issued, and on November 15, bond was reinstated. Again, that was in Outagamie County. No cash was ever ordered. Ms. Bauer did suffer a significant brain injury in 2015. I do not know if that contributed, but that would be my guess. She has some difficulty regarding dates and things of that nature. She did have a neuro assessment done. I do not yet have that, but she is receiving SSDI for that condition. As I stated, she's a resident of Wisconsin. She will not leave the state of Wisconsin. She doesn't have anywhere to go outside of Wisconsin. Obviously, this is a very high-profile case. There's a lot of high emotion going on, but there's also high emotion going on with Ms. Bauer. She's been worried sick, not knowing where her son is. She had been planning on moving back to Two Rivers since the Wisconsin Dells is quite expensive. I don't know what her immediate plan will be, but I would propose that she will attend court hearings with me. She has transportation. She does have the ability to also appear at non-evidentiary hearings by Zoom. I further assert she's not a danger to the community. For those reasons, Judge, we are asking that the court amend the bond to one of a signature.
Attorney LaBrie?
Your Honor, the state is opposed to any modification in bail. As Attorney Larson indicated, the defendant in 2017 had multiple failures to appear for court in Outagamie County in 17 CT 752. She also had that failure to appear in 17 CT 236, as well as the two prior disorderly conduct cases. As far as record outside of Wisconsin, we don't have any convictions for her, but she does have contacts with law enforcement in 2014 in the state of Nevada, one in March of 2014 and one in April. Again, those weren't convictions, but it does show that she has had contacts outside of the state of Wisconsin. The state feels that the cash bond at this point is appropriate. In fact, in light of the amended complaint, I would say it may even be low. We have now changed count 1 to chronic neglect as party to the crime. We have also added the count 4, which involves neglect to another child who is 6 years old from February 14th. So now she's facing additional charges with much higher penalties. These cases obviously involve the care of some very young children. One of the children is around the age of 3, the other is around the age of 6. And not only were we dealing with the defendant sending the child to Two Rivers for discipline, or the boot camp as they described it, to make that child fearful of the co-actor so that when the child returns to her residence, he would behave better. There is also evidence that on February 14th, she left the 6-year-old unattended in a vehicle for approximately an hour in cold weather. The temperature around that time was around probably 27 to 30 degrees with the vehicle turned off. Then we have also, as part of count 1, the chronic neglect on February 16th, leaving the 3-year-old unattended for at least an hour as her and the other co-actor are traveling to locations in the city of Manitowoc, and neither one of them are seen with the child. It's clear that this defendant is facing some serious charges, and there's grave concern. She knows she's facing potential imprisonment, which is an incentive to flee. She also was encouraging the co-actor not to cooperate with law enforcement. On February 20th, she was messaging the co-actor to not say too much. Don't let them, or no, don't talk, ask for an attorney, those types of things. I think at this point, it's clear that cash is warranted. I would ask that the cash either remain the same or be increased. I don't think a signature bond at all is appropriate based upon the totality of the facts, the new charges, and her past record. Judge, I do know there is one victim who wanted to make a statement regarding bail. I don't know when the court would like to hear that.
Right now.
Okay.
If you're done. Yeah.
I'm done with my argument, Judge.
Sure.
The victim wanted me to read their statement because of concern of reading in front of a courtroom.
That's fine. We'll need the name of the person who you're reading the statement on behalf of. If you could give me the name and spell the last name.
Okay. The name is Jody, J-O. And the statement is, I have known Katrina Bauer longer than anyone else, as I am her mother. At this time, I am asking the court to deny any bond modification for a multitude of reasons. I understand bond is not meant to be a punishment, but as an assurance to appear. While you have access to some of Katrina's records, there are records in other states, including Nevada and California, you are not seeing. She has contacts in other states that may be willing to assist her depending on the story she is telling. Her story always depends on her audience. At this time, rather than aligning in locating her son, she feels the need to reiterate what a good guy Jesse is and is fully defending him and his actions. By aligning with him, she could potentially have access to his extended family and ability to flee the area. Katrina routinely will blame anyone and everyone for what happens without taking responsibility for her actions. It goes without saying she is incapable of making appropriate judgments in everyday life, which is likely being available for future court dates and questioning. Katrina has no ties to the community. When I asked her why she would go back to Jesse, she stated, "I felt alone." I can assure you she is well aware of resources available, but she chose not to use them. She severed her relationship with me in October of 2022, so there is no family in the area. While paper will show minimal income, there is unaccounted for income when compared to her spending. I am aware she allowed Jesse to claim her children as dependents on his taxes, and he gave her half the refund they received. I am also aware she receives food stamps for a child not in her care and has miscellaneous unclaimed income. In 2016, while we resided in California and my oldest daughter was having heart surgery in Wisconsin, so I was here with her. At that time, Katrina faked a forced abduction and had missing person reports filed in California. She was located in Minnesota, where she was taken a hold for erratic behavior and drug use. Officers offered to drive her to Wisconsin, and she refused to leave, stating she was there by her own free will. Katrina has struggled with depression and anxiety for many years, has a history of erratic behavior. She has been suffering from traumatic brain injury and is highly likely to forget mandatory appearances. I don't feel it's worth the risk to lower her bond, especially as victim has not been found and many questions are unanswered. She does need to be held accountable for what rules out in the future, and I feel releasing her, she would be a flight risk. I have been the victim on her verbal and emotional abuse for a very long time. If the court finds any reason to reduce her bail, I would like to be assured of my peace and safety with a court-ordered no contact and GPS monitoring.
Right, so the court's primary consideration in determining bail is assuring the defendant's appearance in court. Quite frankly, I haven't seen the amended complaint yet. I don't necessarily know that I need to. There's enough in the complaint that I feel, in combination with her current circumstances, that bail is set right about where it needs to be. And of primary concern to the court is that based on the allegations in the original complaint, her son was missing and she was not being truthful with law enforcement about whether or not she was in the area. That in combination with the fact that she, at least for now, has an address in Wisconsin Dells. I know Attorney Larson makes reference to the fact that, it's the state of Wisconsin, and she may have residents an opportunity to reside in Two Rivers. It's certainly going to take more than opportunity in the borders of the state to make the court feel assured that she would appear. The behavior that's outlined in the complaint in terms of not being honest with law enforcement as far as her presence goes gives me an incredible amount of concern about whether or not she would in fact make herself available for future court appearances. So for those reasons, the court will deny the motion to modify bail. I'll ask Attorney Labrie to draft an order to that effect. Attorney Larson, just as a follow-up to the motion though, in the event she has some definite place to reside locally that might accommodate a daily check-in, that I'm not saying it would carry the day, but it's certainly something the court would consider, and just for the sake of your discussions with your client, okay?
Thank you.
All right. Anything else for the record on this case, Attorney Labrie?
Not on this case, Judge.
Attorney Larson?
No, Your Honor, thank you.
Before we adjourn, then I just want to let the folks generally assembled know I've talked with the district attorney about this so that they can communicate it to the family. I typically don't allow people to wear shirts for missing people or alleged victims in the courtroom, especially once we get to the point where Ms. Bowers or Mr. Vang is going to be in person. I have no problem with the fact that people have them. I understand why. And I got no problem if people want to cover them up with a jacket, but I typically don't allow those to be worn or exposed in the courtroom. It's not the kind of thing I was going to make a big deal about today and have people removed, but I'll let you know going forward. You show up wearing the shirt, you'll be shown the door. So, and it's not for any reason other than I'm trying to maintain the temperature in the courtroom here and not have people get too excited. So with that, we'll be adjourned on this case. James, who's next?
Mr. Vang.
Luke, while we're waiting, you had any luck tracking down Mr. Craig? Hey, Lieutenant Aaron, you said you're here for Craig?
Yes, I am.
Okay, we'll call that one next. Hey, James,
Yes, sir.
Craig's not in custody by you anymore, is he?
Who's that?
We'll go on record in the state of Wisconsin versus Jesse Vang, 24 CF 162. Appearance is starting in the courtroom.
State appears by Jacqueline Labrie.
Mr. Vang appears in custody from the Manitowoc County Jail without an attorney, correct, sir?
Correct.
All right. Mr. Vang qualifies for public defender representation. They've been unable to find an attorney for him yet. I would note Mr. Vang has filed an application for court-appointed counsel. Mr. Vang, what I can tell you is this. The application's a bit premature. I have to give the public defender's office an opportunity, if you qualify, to appoint an attorney for you before I hook the county with that bill. We may reach the point if the public defender can't find an attorney for you where it becomes timely for you to file something like that, and I'll let you know. But for right now, that's not an application the court's going to consider given the fact that they've barely had a week to find somebody for you, okay? All right. Given the fact, though, as I noted, that he does qualify for public defender representation, the court is going to find good cause to continue to toll any applicable time limits, and we'll adjourn the matter to March 14th at,
Judge, do we want to put this at 11?
I was going to say, we'll move this one to 11 o'clock as well.
Thank you.
Anything else for the record from the state?
No, Judge, thank you.
Then we're adjourned. James, who are you giving me next?
You honest?
Back on the record. What was that, Mr. Vang?
Yeah, I just got a question I want to put in a motion for bail reduction.
Yeah, what I'll have you do is this. Put in writing the reasons that you want to have your bail modified. Get that filed through the jail with the clerk of court, and we'll take it up at the next hearing on Wednesday, okay?
Okay. Who do I direct the judge to?
Me.
Okay.
Okay?
What? Your Honor, what's your name?
Robert D. Wayne.
Okay. All right,
They'll
thanks.
help you out. They'll get it to the right spot, okay? It gets filed by your case number as opposed to finding me. So you get something in writing, just make sure you put your case number on it, and we'll talk about it next week, okay, sir?
All right, thank you.
All right, then we're adjourned. James, who you got next?
We'll do Mr. Hipper.
Get ready for an improved news experience. The all-new Channel 3000 news app is here. Tailored for your news the way you want it with a customizable home page. Stay informed effortlessly. Swipe through articles without returning to the home screen. And no more waiting. The new app loads faster than ever, ensuring you get news updates instantly. Download the all-new Channel 3000 news app today. Your gateway to news your way. Powered by News 3000.